taxation provisions and income tax salary. So for this, we have very able speakers, knowledgeable speakers, Advocate K.K. Chythanya sir and C.A. Krishna Upadhyay. I request C.A. Kavita Parmesh to escort them onto the dais and welcome them to the board. Can we have a round of applause? He is also a renowned speaker and author in the field of taxation. He has delivered lectures at prestigious institutions, starting from ICAI, Direct Taxes Regional Training Institute, and various other bodies. He was also a member of the ICAI study group constituted for creating the guidance note on transfer pricing. Additionally, he has co-authored multiple publications on taxation, including books on tax holiday under sections 10A and 10B, decoding section 5 and mistakes of NLR. So with this very brief introduction, I present before you today's first speaker, Advocate K.K. Chythanya. I will also take this opportunity to introduce the second speaker, C.A. Krishna Upadhyay. C. Krishna Upadhyay is a commerce graduate and a fellow ICAI member. He is currently member of Direct Tax Committee of BCAS and charter member of TAI Mangaluru. He has delivered multiple lectures at ICAI, ICSI and several other organizations. He has been on various panels to discuss matters ranging from income tax, international taxation, valuation, FEMA and startup funding, to name a few. Krishna Upadhyay began his career as a consultant with one of the Big Four over more than 10 years. With the Big Four. Krishna Upadhyay has been involved in helping clients with direct tax litigation, India entry strategy, cross-border tax structuring, corporate taxation, transfer pricing, and also has advised various transactions of mergers, acquisitions, sidewalks, etc. Apart from his interest in tax, he is also keenly interested in tech enabling various finance practices, and he is also co-founder of a startup working in this tech platform. So with this brief background, I present before you C.A. Krishna Upadhyay, who is second speaker. Over to you, sir.
Person of Bangalore branch, Madam Kavita Parmesh, the Secretary, Chief and all other office bearers, and the co-speaker for the day, my good friend Krishna, and my dear delegates. Any new thing to me, you like to make noise, right? When we transitioned from 1922 Act to 1961 Act, where we have in the form of section 297 in the 1961 Act, fairly simple provision. Most of us chose to ignore it because we hardly applied to us, and possibly when it was necessary, our grandfathers were doing the internship. But now that we are moving, and we have moved in fact from the 61 Act to 2025 Act, the transition provision has become extremely critical. And it is important that we spend considerable time going through these provisions, understanding its nuances, and getting a parcels for the various reactions from the department's end. For this purpose, we will have to essentially look at section 536 of the ITA 2025. In fact, the transition provision of 536, before it could take effect from 1st of April of 2026, was already subjected to amendment by Finance Act of 2026. There are about 90 plus amendments which have been carried out. If there are not to be a policy change and it's just the case of restructuring, to make it simpler, it wouldn't have required 90 plus changes before the Act would ever come into effect. That itself shows you that it's not the case of policy change. There have been not many changes which go far beyond being called as a policy change simpliciter. And you would start feeling the heat of it once the assessment orders would start rolling out, not on a podium like this. The assessment units, which are essentially faithless as well as heartless, will start making insane additions on the basis that the provisions of ITA 2025 are materially different from ITA 1961, in which case people like us will have to be making lots and lots of money in the course. Be that as it may, now we'll start going through this very, very critical section. And you have to excuse me because it tends to be super technical. I will go very slow. I will not want to rush through this. I would request you to kindly look at the screen very carefully. And I'm very sure, like how it happened to us when we did the initial reading, that it will go beyond our shoulders. But then, it would also make it necessary for you to go back and get into a study mode in respect of this particular section. Imagine the situations that could arise and gear up yourself to handle this. In my limited ability, I have tried to imagine some situations, tried to make it look practical by bringing in some like aspects that would require immediate attention. And as we go about it, I'm sure we'll face more and more of such situations and we'll have to be getting ready to handle them. Now, section looks fairly simple. It has 4 subsections. Subsection 1 is the necessary effect of the new Act being born. It says the 1961 Act is hereby repealed, means it's gone. Then comes subsection 2. It says irrespective of repeal. No, they are not using the word notwithstanding. Now they use the word irrespective of. What is the objective? To make it simple and to reduce the size. Irrespective of the repeal of ITA 1961 and subject to subsection 4, then you have various clauses A to U. Clauses A to U, which I will be taking you through each one of them a little later. So the structure of subsection 2 is that the irrespective of the repeal, notwithstanding the repeal, you'll have to look at A to U to see as to how we transition from 61 to 2025 Act. Subsection 3 is very important, extremely important. I'll explain this in greater detail a little later. It says that wherein a reference is made in ITA 2025 to any tax year commencing on 1st day of April 2025 or any earlier tax year, the same shall be construed as reference to the corresponding previous year under the Repealed Income Tax Act. So wherever they would say tax year, and as you know, we don't have the concept of the previous year and the assessment year anymore, we just have the concept of tax year. The moment they say tax year, and if the tax year were to relate to 25, 26 and earlier, you'll have to construe them as what? The corresponding previous year of the repeal act. This is extremely important. I will also explain the role this particular subsection plays. Then go to subsection 4. Without prejudice to the provisions of subsection 2. What is subsection 2? Irrespective of repeal, you'll have to look at clauses A to U. So it would override the repeal, meaning for the purposes of A to U, the repeal would not take place, the ITA Act of ITA 1961 would remain. To what extent, in what manner it would remain is something for us to discern as we go into each of these clauses. Now, it says without prejudice to the provisions of subsection 2. The provisions of Section 6 of the General Clauses Act of 1897 shall apply with regard to the effect of repeal. If you go to General Clauses Act, apart from various sections, it has Section 6 deals with the repeal of any central act or regulation. Whenever any central act or regulation is repealed, what will happen thereafter? To what extent your rights and privileges would stand protected? To what extent your liabilities that have incurred would still remain? To what extent the offences that are committed and the repealed act would be tried thereafter? So these are all dealt with by Section 6 of the General Clauses Act. As you could see, here itself there is a problem. Look at subsection 2. It says, irrespective of repeal of Income Tax Act and subject to subsection 4. What does it mean? Subsection 2 is subject to subsection 4. It means what? Subsection 2 is to subsection 4. And now we go to subsection 4. It says without prejudice to subsection 2. Which means what? It is actually militating against the mandate of subsection 2. Are you able to get me? Yeah. So simple errors like these, if we cannot draft, we are a country of about 1/4 the population of this planet. We can't make such simple law. Having said subject to in subsection 2, why are you having without prejudice? In fact, the law was a little different. In the original draft that came, it was like this. Then came the enactment, wherein that only made it subject to subsection 3, they did not make it subject to subsection 4. Whereby, the words without prejudice that would come in subsection 4 would have had some meaning. Now they conflict with each other. While 2 would say, I will yield to 4, 4 would say, don't yield to me. There will be some issues that would arise a little later in respect of this. Now, one thing we have to understand is what is made part of subsection 4 is only section 6 of the General Clauses Act. There are other provisions in the General Clauses Act as well. For example, section 8 of the General Clauses Act, section 24 of the General Clauses Act, which will deal with the repealed enactment. What does section 8 say? Section 8 only says this, that you have Income Tax Act of 1961, correct? You will have Companies Act, you will have GST, you will have FEMA, you will have Black Money Act. Other central enactments would have made a reference to 1961 Act. Now that 1961 Act is killed and a new Act is given effect to, they don't have to go and make amendments to all these central acts. And they will then understand that the reference to ITA 1961 should be construed as reference to ITA 2025. If you go to, for example, section 6 of the Black Money Act, section 10 of the Black Money Act, if you go to section 16 of the GST Act, where references are made to the Income Tax Act of 1961, those references in terms of section 8 will have to be construed as references to 2025. You have section 24 of the General Clauses Act. It says any notification, any order, any circular, any communication issued, any rule issued with reference to the repealed enactment which is ITA 1961 shall be construed, shall be deemed to have been issued under 2024 Act till such time the parallel rule, parallel circular, parallel notification is issued that would have the effect of automatically rescinding the old notifications which are deemed to have been issued under 2024 Act. So if some notification is missing, not found in 2024 Act, what is issued in 1961 Act shall be deemed to have been issued under 2025. However, Section 8 which I referred to, Section 24 which I referred to would apply unless and until contrary is provided. Keep this in mind. only when contrary is not provided. If the specific enactment provides something to the contrary, then those sections of the General Clauses Act would not apply to it. Because we find situations where something to the contrary of section 24 of the General Clauses Act is provided in section 536(2), which will go to it later, and then bring back section 24 of the General Clauses Act and try to link it to this to see as to what extent section 24 would apply. So this is how we'll have to understand the basic structure of section 536. Before I am done with subsection 1, I am done with subsection 4 provisionally. Subsection 2 has clauses from A to U that will take time, I will go there. Now let's look at the more simpler section, that is subsection 3. I already mentioned this to you as to what subsection 3 provides. As I said earlier, in the ITA 2025, they keep referring to tax year. So what we'll have to do, figure out what is the tax year. It's a period of 12 months commencing on 1st of April, it's a financial year. If that were to relate to any period 25, 26 and earlier, when this ITA 2025 did not exist, that would be understood as previous year. Now I have one problem. This is applicable to whole of ITA 2025. Across ITA 2025, wherever you would go, wherever reference is made to tax year, if it were to relate to 25, 26 and earlier, constitute as reference to previous year. So I'll explain to you how it works, but there is one problem. Section 536 as was originally enacted by the Parliament before it got amended, subsection 2 had said, instead of saying subject to subsection 4, it had said subject to subsection 3. I would understand. Now wrongly it says subject to subsection 4, because subsection 4 already says without prejudice to subsection 2. It is not required for it to have stated subject to subsection 4. It had correctly stated earlier that 536(2) is subject to 536(3). That means whatever is the construction of subsection 3 would not only have applied to whole of ITA, it would have also applied to 536(2). Now they have substituted it. It is no more subject to subsection 3. Now the question and the problem that we have is as to the implication of this in as much as if we refer to tax period of 25, 26 and earlier, whether it will apply only to rest of the Income Tax Act of 2025 because 536(2) or would it apply to 536(2) as well? The reason is, even when you go to 536(2), which is the most important section of our discussion today from clauses A to U, references have been made to tax year, and some of these tax years would relate to 25, 26 and earlier. Would we present to service the provision of 536(3) even for our understanding of 536(2), despite the fact that it is no more subject to subsection 3 is the point for consideration. Looks a little complex, but unfortunately you are listening to a lawyer. Don't worry, everything did not sink in here. We have struggled enough. I want you also to struggle. So it takes some time. Just apply your mind to it. This is one aspect. Now, leaving that aside, let us assume for a while that even for subsection 2, the provision of subsection 3 would apply. Let us assume. Otherwise, whole of subsection 2 gets killed. We have to assume. You cannot interpret a provision in a manner so as to render it nugatory. It has to be understood in a workable manner. For whatever it is, we will understand and assume that this construction should apply to whole of the Act, including subsection 2. With this, let us now try to understand the implication of this. I will give you some illustrations. I will explain some of them. Then how it helps and how it it doesn't help. One is the case of section 301 clause A of 88/2025, which will correspond to 158 capital B clause A, block period in the case of such assessment. How this subsection 3 works? Another is the case of 94B, T capitalization, where 30% of EBITDA would have been the cap of interest allowance in respect of payout of interest to a foreign company AE. And wherever there is a shortfall of allowance, that would be allowed to be carried forward. That's the provision of 94B, which corresponds to 177. See, these are all the, the legacy issues that are flowing from ITA 1961 to ITA 2025. That is where the meaning of tax year matters. 80JJAA, section 146. Compensation to new workmen. If you would incur 100 rupees, you get 30 rupees for 3 years. So you would have incurred it in the regime of 1961. You move into 2025. How are you enabled to claim it for next 2 years in the new regime? Section 530, which corresponds to 294, where on the first day of the tax year, the Finance Act is not enacted. Finance Act is not in place on the first day of the tax year. Would it mean it till the charge of section 4 is dealt with by section 530, which corresponds to 294. Then you have section 41(1), which corresponds to 38(1)(a). What is 41(1)? You are carrying on a business. There has been an allowance in respect of any expenditure or a trading liability. Then you get some benefit by reason of cessation or waiver. Then, in the year in which you get such benefit, you will be charged to tax. Because you are allowed the deduction and the time when you claimed it. And the expenditure did not remain as such in a subsequent year, which will warrant to call back the deduction by adding it back. Like that's corresponding to 38(1)(a). To take 41(4), recovery of bad debt. Bad debt would have been allowed to you, but you end up recovering a portion of it or a part of it. In which case it will be charged to tax. That is dealt with by 38(1)(d). So these are some of the things where some events, the triggering events that have taken place in the 61 Act, the consequences are felt in the 2025 Act, and that is where the meaning of tax year will become critical. I'll explain how. Look at 301 within brackets here. Under 536 subsection 2 clause U, which we will discuss a little later. If a search were to take place, a search is initiated on or before 31st of March of 2026, then ITA 1961 would apply to it. However, if a search is initiated on or after 1st of April of 2026, that is the first day of ITA 1961, the ITA 2025, provisions of ITA 2025 would apply, which will be 301 clause here would apply, which will deal with the such assessments, and 301 says what is the block period. Let us assume such take place today. Are we in 2025 regime or 1961 regime now? We are in 2025 regime. Such takes place today. How is the block period to be computed? It would say that the 6 tax years preceding the tax year in which the search has taken place. Which is the tax year in which the search has taken place? 26, 27. So 6 years would be which year? 25, 26 and earlier. That means you are referring to tax years, referring to 25, 26 and earlier. Then 536(3) says, wherever we refer to a tax period which is 25, 26 and earlier, they have to be understood as? Are you clear, sir? This is how it works. There will be some other issues here which will come to little later. One issue would be that 301 clause A says, as soon as the search is initiated, the pending assessments under this Act abate. When is search initiated? today. What are the pending assessments as of today under this Act? None. Because all the assessments relate to tax periods under the old Act. So they have not addressed this, which will mean what? Those pending assessments of the repealed Act would not abate. They will continue and you will have a parallel block assessment happening. What they should have said, the assessment that are pending under 2025 are under the repealed Act shall abate. They should have said that. They have not done that. Which will mean you will have parallel assessments happening for a search that takes place today. The 6 years that will fall into 1961 Act, you would have the proceedings going on there as well as you will have the proceedings going on here. Which will mean you will have to then go to the court and figure out what has to be done. The court will have to interpret and you will have an amendment coming very soon thereafter. Now let's look at the next one. 94B, which is the capitalization carry forward of the interest allowance not allowed. Only 30% would have been allowed, we still have carry forward of interest. If you look at 177 subsection 5, it says, look at this language, interest not wholly deducted against income and the profits and gains of business or profession for any tax year shall be carried forward to following tax year. So meaning, let us say in 23-24, in the old regime, there was a disallowance of 5 crores under 94B because it exceeded 30% of EBITDA earning before taxes and depreciation. It exceeded. So 5 crores would have been disallowed under 1961 Act 94B for 22-23. Right? Now, next 2 years, let us say you did not have enough of profits or whatever you had losses, now you move into the new regime. When you move into the new regime, you are allowed to carry it forward. Because the reference made here is to any tax year. Now, which is the tax year? 22-23. It has to be construed as previous year. And therefore, the transition is smoother. It is addressing it well. Is it clear? Now, let's look at a little more complicated section. 80JJAA, which corresponds to 146. Look at 146 on the left hand side carefully. Subject to the conditions specified in subsections 2 and 3. If the gross total income of an associate to whom section 63 applies, just the same as 80JJAA, includes any profits and gains derived from business, a deduction of an amount equal to 30% of the additional employee cost incurred in the course of such business in the tax year should be allowed. 30% would be allowed. Then we'll have subsection 2. The deduction referred to in subsection 1 should be allowed for 3 consecutive tax years, beginning from the tax year in which the employment is provided. So what it says, 30% for 3 years. Now a lot of interesting things would come. The reference is made to the tax year in which you have incurred the additional employee cost. Let us say in 24-25, let's take 25-26, the last of the previous years. In 25-26, you are an eligible assessee for 80JJAA. You have satisfied the condition. You have incurred about, say, 10 crores as eligible employee compensation. You get how much? 30%. 3 crores for 3 years you should get. So if this act had not been repealed and a new act had not come, you would have claimed 3 crores for 25-26, 3 crores for 26-27, another 3 crores for 27-28. Correct? Now what it says is 30% of additional cost incurred in the course of such business in the tax year, which is the tax year did you incur 25-26. So what has to be the construction of the tax year? The previous year. Correct? So the previous year you incurred, then you should be eligible to claim 3 crores in 26-27 and 3 crores in 27-28 by the proper construction of 536(3). But there is a problem. Look at this language carefully. It says, subject to the conditions specified in subsection 2 and 3, is the gross total income of an assessee to whom section 63 applies. What is 63? It corresponds to 44AB. Now, are you a person at the time when you incurred this 10 crores to whom section 63 applied? Did section 63 exist? What existed then? It's 44AB. 63 did not exist. The literal reading of this, knowing the assessing officers, they would say, are we a person in 25-26 who is subject to section 63 of 2025 Act? Yes or no? The answer has to be the negative. What was applicable to is 44AB. Then they would say, look boss, sorry, you will not get another 3 crores for 2 years. Because you don't come under section 146. However, you can't stop this. If somebody says you won't get it, will you stop? Then you have to see as to how best you could manage it. Manage it under law. Now, look at this. Now, if you see this, section 536 subsection 2 clause B says, the repeal shall not affect any right, privilege, obligation or liability acquired, accrued, incurred under the repeal act. Can you call in 25-26 when you comply with all the conditions of 80JJAA, you being a person carrying on business, having business income, being subject to tax audit under 44AB, having incurred 10 crores, otherwise no disputes, did you earn a right or a privilege to claim these 3 crores for next 3 years, yes or no? If you would say yes, irrespective of 146, irrespective of its unfriendly language that you shall be subject to section 63, which section never existed, you have a case to make out that you should be true. But then there is another problem here. The problem is, what is the meaning of right? What is the meaning of privilege? I am trying to right because in the year 25-26 I satisfied all the conditions. There is nothing more I need to do for next 2 years. So the privilege that I want, you can't take it away. Is my argument. But then what the department does is, it will ask me a question: is this right, inchoate right, or an absolute right? What's your call on this? Is it an absolute right that you will get 3 crores for next 2 years, or it's an inchoate right? If you see section 80JJAA or the paragraph of 146, it says you shall be an assessee to whom section 63 or article maybe 44AB shall apply. That means in whichever subsequently you are claiming 80JJAA, you shall be a tax audit case, and your gross total income shall include profit sharing gains of business or profession. So it comes in some conditions. If those conditions are not met, you will not get. So therefore the department argues an inchoate condition. Inchoate right is not a completely accomplished right of privilege, and I will not give you the benefit. So how do you address it? You can address it by going back to section 8 of the General Clauses Act. Now if you go back to this is why I mentioned it ago. Just don't look at section 6 of the General Clauses Act, section 8 of the General Clauses Act. What it says is, if any reference is made in the repealed enactment, which reference is made in another enactment, a reference in another enactment to the repealed enactment could be construed as reference in the newly enacted law also. You can possibly make use of section 8 also to see as to reference to section 63 could be understood as reference to 44AB. So these are some challenges that would be available to you, which will have to be taken care of. And this is where the transition provisions do matter. So now as you proceed, I will not get into section 530, except saying that 530 would state that on the first day of the tax year, the tax law should be in place. That means Finance Act should get the assent of the President on or before the first day of the tax year. For some reason, if there is any problem and you don't have the Finance Act, which receives the assent of the President before the first day of the tax year, which is 1st of April, then how do you handle it? You will go by the Finance Act for the preceding tax year. What is the preceding tax year here? The preceding previous year. And therefore, we have to apply the Finance Act of 2025 and not the 2026. In case the Finance Act of 2026 is not enacted before the first day of April 2026, we don't have that problem. The presidential assent had come before the first day of April 2026. There is no issue on that. Likewise, if you go to 38(1)(a), which corresponds to 41(1), during the Income Tax Act of 1961 regime, you had claimed some trading liability. You follow the upward system, you claim some trading liability. And there is a waiver of the debt which you owe to the creditor that will take place in the 2025 regime after 26-27. So because the trading liability was allowed in the tax year, which tax year is prior to 25-26 and earlier, now to be understood as previous year, and subsequently after the new regime comes into play, if there is going to be any waiver from that creditor, you are going to pay tax under 38(1)(a) because of operation of 536(3). But there is one interesting aspect here. If you go to section 41(1), it is not only the assessor who had obtained the trading liability as a deduction who would have to pay the tax. If there is a successor to him, let us say Naveen is carrying on some business, he had claimed some deduction, I become successor to his business, and in my regime, as I run the business, if there is a waiver from the creditor who had supplied goods to Naveen takes place, under 41(1) I become liable to pay tax. There is no such provision in the 2025. The successor is not liable to pay tax. Whether or not you make a grievance out of it, it will get immediately corrected if they hear us. No matter whether your grievances will be addressed or not. Similarly, you have 41(4), recovery of bad debt would also be addressed here. If bad debt is allowed in the old regime, recovery happens in the new regime, it will be charged to tax in the new regime because of play of 536(3). So these are some illustrations of 536(3), where reference to the tax period of 25-26 and earlier will have to be understood as reference to the corresponding previous year. Now let's go to 536(2), clauses A to B. Clause A is corresponding to section 6B of the General Clauses Act. I have given the text of 6B of the General Clauses Act also here. Nothing shall affect the previous operation of the repealed act and orders of anything duly done or suffered thereafter. So just because the 1961 Act is repealed, you can't take a position that the orders passed there are no more relevant, you don't have any more liability to discharge, nothing. Whatever previous operation under the repealed act has taken place will remain sacrosanct, completely valid. Subject of course to you fighting it against it in appeal and the court calling it invalid or whatever, otherwise it will operate. This is just the same as section 60 of the General Clauses Act. This is important, which I was trying to tell earlier, that the repeal of 1961 Act shall not affect any right, any privilege, any obligation or any liability acquired, accrued or incurred under the repealed Income Tax Act or orders under such repealed act. So now we have an interesting decision of the Constitution Bench in Banshidar versus State of Rajasthan, where the Supreme Court stated that right, liability, etc. should not be inchoate right or liability. It has to be completely crystallized right or liability. Language you will accrued or incurred. So it's already devolved on you. So this is where we try to argue that as a notice under 147 is issued on 31st March of 2021. A notice under 148 is issued on 31st March of 2021. On 1st of April, entire reassessment is revamped. And in place of reason to believe, you have information suggesting escapement. will have a new procedure of 148A or whatever. Can Section 6B or rather 6C of the General Clauses Act save the notice issued on 31st March of 2021 under the old regime? So we have found the repetitions in Karnataka High Court and elsewhere. They are taking the position that the notice issued on 31st March of 2021 has died. It has not created an accrued liability. It is just a notice. It may be dropped and assessment may be passed without making an addition. So no liability has crystallized, no liability has accrued, just a notice has been issued. So the moment it is substituted by new set of sections, it will kill that notice. And if the department wants to revive it, it has to issue a fresh notice under new law. So this is where, like Section 6C of the General Clauses Act should matter. And here in 536(2)B we have the replication of 6C of the General Clauses Act. This is extremely important. Next is 536(2)C, and before that there are certain other provisions in Section 6 of the General Clauses Act. 2 or 3 of them are covered. Your clauses A to E, only 2 or 3 are expressly covered. Rest are applicable by necessary implication in terms of 536(4). It says that the provisions of Section 6 of the General Clauses Act would apply to the repeal of the Income Tax Act of 1961. Now we move on to Clause C. One of the most important clauses. It says the provisions, irrespective of repeal, all these clauses will have to be read with the preamble words, irrespective of the repeal of 1961 Act. The provisions of the repealed Income Tax Act shall continue to apply to any proceeding pending on the date of commencement of this Act, that is as of 1/4/2026, or to any proceeding initiated on or after 1st of April 2026, including notices, assessment, reassessment, recomputation, rectification, penalty, reference, revision, appeal, in respect of any tax year beginning before the 1st day of April 2026. Tax period beginning before 1st of April 2026, and such proceedings shall be carried out as per the procedures specified in the repealed Income Tax Act. What it tells you in fact? It keeps the whole of the Income Tax Act of 1961 live and kicking insofar as it relates to the tax periods 25, 26 and earlier. You can't jump the ITA 1961. You have to keep them in your library, because any proceeding relating to 25, 26 and earlier, which act will apply? ITA 1961. It would not apply only on the procedural part of it, substantive part as well as procedural part, which will mean ITA 1961 in entirety would apply. In entirety would apply to previous year 25-26, tax period 25-26 and earlier. This is an omnibus provision. It starts with 2 aspects. It begins with the word provisions of the repealed act would apply, all provisions. And it ends with the second link which says such proceedings shall be carried out as per the procedure specified in the repealed Income Tax Act. So the starting words would apply to all the provisions of the Income Tax Act, including substantive provisions like the charge, computation, etc. The ending words of Clause C that would talk about such proceedings shall be carried out as per the procedures specified in the repealed Act. That means all the assessment procedures, recovery procedures, etc. shall follow under the 1961 Act. Irrespective of when it is done, whether it is pending as of 1st of April 2026 or it may be initiated now. If you want to file a revised return, if you want to file an updated return, if you want to file a return under 148 in pursuance to notice under section 148 under 1961 Act, up to whatever limitation you will have. For example, updated return can be filed up to within how many years? 4 years. So, which is the last of previous year under 1961 Act, 25-26. Assessment year, 26-27. 4 years, meaning 31st March of 2031, correct? So 21st March of 2031, up till then, you can file an updated return, and which form and which rule and which act would you be following? 1961. And to that notice, at that return you get a notice thereafter. Then we'll have an assessment, then you'll have an appeal, and go to Supreme Court, minimum 15-20 years. Which act will apply? Take the case of reassessment time limit under 149. 5 years, 3 months or whatever. So 5 years, 3 months, you would apply to 25-26. Again you will have a notice coming under 148 right up to 31st March of 2031. And when you get a reassessment notice now, according to Finance Act of 2026, in pursuant to reassessment notice, you can still file an updated return by paying an extra tax. So you still have time to do it. Again you will have an assessment happening in respect thereof. And which act would apply? 1961 Act would apply. So therefore, kindly don't rush to forget 1961 Act. In fact, we had a Chythanya 13th edition being released in Delhi. We had Justice Upadhyay, who gave the talk on the occasion of the release of the book. He said, don't worry about 2025. The presiding judge of the Honorable Supreme Court stated, don't worry about the 2025. These volumes will stay in the library for next 30 years. Because he would know too well that he would be handling tax matters relating to 95, 96, 97, 98. Now we are in 26, 27. And there will be some interesting things here. See, general rule is that if the tax period is 25, 26, old law will apply. If the tax period is 26, 27, new law will apply. But there are some exceptions. One exception could be a search taking place. When the search takes place on or before 31st of March of 2026, obviously which will be the block period? 6 years. But block period would also include the period up to the time when the last of the authorization is executed. That could be executed in the new regime. Are you able to get me? So that will have an admixture of some portion of 1961 Act period, some portion of 2025 Act period. This will get assessed by 1961 Act because the search is initiated on or before 31st March of 2026. I'll repeat again, the block period is not just the 6 preceding tax years. Block period will go right up to the time, not when the search is initiated, but up to the time the last of the authorizations of the search warrants is executed. Take a case where 25th of March of 2026, search takes place, initiated, execution will happen in 2027. So the block period will be not only past 6 years, but also will go up to 2027, which will have an admixture of some period of 1961 Act, some period of 2025, but which Act will administer it? 1961 Act will administer. In the reverse case, such takes place today, will have a portion of this year and 6 of the tax periods relating to 1961 Act, but will be assessed on the basis of 2024 Act. It's an exception to clause C. Though the tax periods comprised in the block period would relate to 25, 26 and earlier, because of 536(2)(v), the provisions of 2025 Act alone would apply and not the provisions of 1961 Act, even though bulk of the block period would relate to the period during the 1961 regime. Looks a little complex, but this is how it works. Don't worry, another 20 minutes to bear with me. I'll wind up by that. Now look at this. Needless amendment. Clause D. See, clause C is omnibus, then you will have other clauses coming in which will possibly act as an exception. Now what does clause B say? Any proceeding for the imposition of penalty in respect of any tax year beginning before 1st day of April 2026 may be initiated. That means 20, 25, 26 and earlier, an offence committed by you, penalty may be initiated under the Repealed Income Tax Act as if this act had not been enacted. First question is this clause required? Go back to see. Would it not have penalty within the brackets? Look at the bracketed words. Assessment, reassessment, recomputation, rectification, penalty is already there. What was the need for clause B? Somebody is sitting earlier here will have to explain. Number one. Two, now that they have had this clause, what is going to be the argument? It is not hit by clause C, it is hit by clause B only and no other clause. General yes, special yes, non-directed. General clause C will lead to special clause D, correct? Now, if you go to the special clause D, if I had remained in clause C, there would not have been any difficulty because both substantive and procedural, not only levy of penalty, it is not enough if the penalty is levied, that has to be taken out of your pocket, right? Recovery will have to take place. So clause C would have handled all that. Now go to D. It only deals with imposition of penalty, doesn't deal with recovery of penalty. As if this act had not been enacted. And what can be done under the Repealed Income Tax Act? Only imposition. What about recovery? What this clause needed? Needlessly putting a clause, they must have thought that will make it very elaborate and comprehensive enough to cover. In the zeal of making it very comprehensive, they have missed out the vital aspect of it. And they are not provided for it properly. Look at this carefully. Any proceeding for imposition of penalty. Penalty imposition proceeding is not the same as penalty recovery proceeding. Once an order of penalty is passed under section 270 capital A, it doesn't end with that. It has to be backed by a notice of demand under 156. That is the recovery proceeding. It doesn't address the recovery proceeding. It only says imposition will have to be done under the Repealed Income Tax Act. As if new act has not been enacted, so you can't apply the new act for recovery because they themselves are providing that as if no new act is enacted. What is it? It doesn't mean, like if somebody wants to levy penalty, go and tell him do whatever you want. Then amend this later. So please attend to penalty proceedings and ensure by whatever means penalty is not levied. Right? Now this again is a replication. Any proceeding pending on the commencement of this act before any income tax authority or any other authority under the repealed act, appellate tribunal, any court, by way of any application, appeal, reference, revision or by any other means shall be continued and disposed as if this act had not been enacted. It's already there in clause C. Look at the bracketed words in clause C. It's already there. Appeal, reference, revision, all that is there. And it's including. So therefore it would have even, like consisted of application, all other such like proceeding would have come. No need to have this clause at all. This is important. Any election, declaration made, option exercised by an assessee under any provision of the Repealed Income Tax Act and in force immediately before the commencement of this act shall be deemed to have been an election, declaration made or option exercised under the corresponding provision of the new act. Very, very important. See, you would have elected a particular provision where the law demanded, you would have opted for a particular manner of assessment. Law would have demanded for you to exercise that option. And such option shall be in force when the new act comes into being on 1st of April of 2026. In such case, whatever election or option that would have exercised under the 1961 Act, under whatever provisions, you are deemed to have made such election or option under the corresponding provisions of the new act. You don't have to do all over again. They are very, very important in the use of provision. There is some interesting fallout also which we will discuss now. I understand about the election. You elect to be, like, for example, under 10 AA, you may opt out if you do not want it. You opted out of it. Under 115 BAA or BAB, you would have opted to be covered by the new regime. Those would also apply in the new regime. You don't have to do it all over again. Like, for example, you have section 200 of 2025 that corresponds to 115 BAA of the 1961 Act, the 22% regime. You opted for 115 BAA under 1961 Act. You are deemed to have opted for section 200 under 2025 Act. Likewise, your 115 BAB, that 15% for the manufacturing companies, the new regime, you will have it covered under 201 of the 2025 Act. So those are the options that will continue. Whereas, look at the option under 115 BAC. Is it a perennial option or year-on-year option? So year-on-year option. So it wouldn't be in force as of 1st of April of 2026. So that option would not bind you in the new regime. You will have to be choosing for it all over again. You've gone in for 4480. Are you stuck to it for at least 5 years? 2 years are left under old regime. Next 3 years you are stuck to it. So it's a continuing option. You are deemed to have not opted out of it. You are deemed to be covered here. What about 4488? Is it a continuing option or year-on-year option? So is 44AE. So corresponding provisions of 58. So you can't be, like assuming that whatever option you exercised under 1961 would continue to apply. So you'll have to apply your mind, look at your option and see whether the option is a one-time option or year-on-year option. So one-time option, that will continue. Year-on-year option, it will not continue. So you have to be careful about it. Now there is a reference to declaration. So this gives rise to some interesting things. What declaration do you make in Income Tax Act? What declaration do you make? You declare that whatever you have stated above is true and correct. Is a declaration that you have made correct? Will it be deemed to have been made under Computer Act? The answer is no. So the use of what declaration is not very apt. We don't have a binding declaration. Generally in the 1961 Act, we have option, we have election. We don't have a declaration. Whatever declarations we have shouldn't be mistaken to be a declaration here because we apply the legal principle of interpretation called non-citable sources. So when you have declaration that is sandwiched between election and option, the declaration will have to also have the meaning that is similar to an election or an option. It can't be given an alien meaning. So declaration here will have to be understood in the limited context of something which is similar to an option, something which is similar to an election. It would not include the choice that you would have made. You would elect to marry, but you choose your spouse. So what is covered in only election, not the choice. So whatever choices that you would have made, like you choose to go to DRP, not to the commercial period of 144B, that would not bind you for subsequent years. So these are some of the aspects that have to be kept in mind when you look at 536 2F. Some interesting provisions, interesting practical issue that would arise here. See, we were examining Finance Act of 2026. Some material change has taken place in MAT. Right? What is the change that has taken place in MAT? They have said that, look, MAT credit would be given to you only when you move to the new regime of section 200 or 201. That means if you are a company and if you have paid MAT, if you have the MAT credit accumulated, earlier you could have taken it to subsequent year and in that subsequent year you could have offset the MAT credit against the delta. What is the delta? Excess of normal tax over the MAT tax. You could have offset it, correct? But Finance Act of 2026 brought in a provision. Section 206 of 2025 Act, subsections 3 and 4 have been brought in. where a material change has taken place in subsection 3 where the MAT credit of domestic company. Insofar as MAT credit of foreign company is concerned, there is no change. Insofar as AMT is concerned, alternate minimum tax for non-corporate, there is no change. But MAT credit for a domestic company has undergone a change. What is the change that has taken place? If we remain in the old regime, we will have to forego the MAT credit. Old regime means 30% tax or 25% tax for a company. Old regime does not mean 1961 Act. Old regime means normal rate of tax. If you move into the new regime, that is section 200 and 201, that is 22% tax without the deductions, 15% tax for a manufacturing company without the deductions, then you don't come under MAT in those years where you are under 200 and 201, number one. Two, you will also get the MAT credit not exceeding 25% if a tax liability in each year. I would understand this. Basically, MAT credit is lost unless and until you move to section 200 or 201 as a company. If you stay out of 200 and 201, you have huge MAT credit of 5 crores, 10 crores, all gone. Clear? This is the approach. Nowadays, the board has the habit of issuing FAQs. What is FAQ? Frequently asked questions. It should be FQS. Frequently questioned answers. None of us would have had the question to get ready to read here. We are ready to read and get, by which time the FAQs would have come. I do not know who would have asked the questions to board. They themselves would have asked the questions. Meaning, look at how they are making law. There are so many questions to themselves. The minute after the act is brought or the bill is brought, the FAQs would come. One of these FAQs, the question was invented for an answer that already existed. Is that somebody asked, I was having MAT credit, here we get very interesting, I was having MAT credit up to 23, 24, say 10 crores of MAT credit. Up to 23, 24. In 24, 25, I moved to 115 BAA for some reason. When I moved to 115 BAA, MAT provisions don't apply to me. Meaning I will never have an occasion of normal tax exceeding MAT tax because MAT provision would not apply. I would have lost the 10 crores, correct? So I was advised, don't bother about these 10 crores of MAT credit, which are acquired up to 23, 24. Forget that. You will have better benefits. So 24, 25 onwards, I came under 115 BAA or BAC. I gave up that 10 crores credit. Now, after the Finance Act of 2026, by way of amendment to section 206 subsection 3, they have said that look, if you move to the new regime of section 200 or 201, that is 22% or 15%, whatever MAT credit you had will allow you each year not exceeding 25% of that year's tax liability. See, what was never eligible then when I gave up the credit of 10 crores became now available. Are you able to understand? The board said no, you don't get it because you already foregone it into old regime. Board said you don't get it because when you move to the special regime in 24, 25 when you had the credit of 10 crores, you knew that you would have lost the 10 crores benefit, we will not give you now. Is there an answer to the FAQ? Which answer is completely wrong because of clause F. What clause F says? Whatever election you have made, whatever choice you have made under the 1961 Act, what choice did you make in the 1961 Act? In the year 24, 25, you chose, you elected, you opted to come under 115 BAA. In terms of clause F of subsection 2 of section 536, you deem to have made such election under section 200 or 201 of the 2024 Act. The moment you are deemed to have made an election for section 200 and 201 under the 2024 Act, you qualify under section 206 of section 3, you shall be eligible to get the matter. So the FAQ is wrong. The answer to the question is wrong. Because those who framed the answers did not look at 536 to left. Now there are some other issues here. You can make options not only under the Act but also under the rule. What section 536(2)(f) protects is the option that are made under the provision of the Act. It would not protect you for the option that are made under the provision of the rule. I'll give an example. You are a power assessee, meaning you are an assessee engaged in generation and distribution of electricity or any other form of power. What kind of depreciation are eligible? Straight line. Act does not give you a choice. But if you go to Rule 5, so Rule 1 capital A, it will give you a choice. You can elect to go for WD. But once you exercise the choice, you have to. Now take my case. I'm a power assessee. I opted for WD because I can accelerate the depreciation through WD. Let's say I've almost claimed up to 80-90% of my actual cost. And the option I made not under the Act but under the rules. Now I come to 2025 Act. 536(2)(f) would not carry that option to 2025 Act. I am not deemed to have made a similar option under the corresponding new rule. There is no such transition. Which will mean what? I am not eligible to continue this WDV. I will become eligible for straight line. So what I will do? I will start claiming straight line all over again. Are you able to get me? Irrespective of fact that 90% of 100 rupees, right? Let's say 100 rupees is actually the actual cost. I claim WDV up to 90 rupees. I move into new regime. Then under new regime I am no more eligible for WDV, nor am I going to go under WDV because my choice is gone. There is no protection for the choice that I made. That means I am eligible only under straight line method. Now if I go for straight line method, I claim on 100 rupees and keep claiming for next 10 years. Assuming the depreciation rate is 10%. So these are some of the issues that are not addressed at all. Another provision again not required, 536(2)(g). If any refund falls due under the old Act, refund falls due now. Likewise, the demand arises now because of the default which I have committed now, but it relates to the past year. How it is to be recovered, how it has to be addressed, all according to old law, but with the substitution of the rate as per the new law. Except the rate, nothing else will change. Supposing under is not changed, rate also is changed. Refund rate is 6%, half a percent per month. Let's say they make it 9%. Never ever they do it, but let's assume very fondly that they make it 9%. And you have some refund now arising to you relating to the past period, but post 1/4/2026. So the period after 1/4/2026, you will get 9% interest. Likewise, the 234 ABC interest, 220 subsection 2 interest, all these interests, if the default is committed now, from 1st of April 2026 onwards, the new rate would apply, but all the provisions of the old Act will continue. There are some material errors which will not get into because it will not be important at this point in time. Now, this is another important provision. Krishna, will you prefer another 5 minutes? What will be the key break? There is something to it, right? 5 minutes, okay. The 5 minutes are okay?
Yes, sir.
Clause H. Clause H says, if in the 1961 Act, any sum has been allowed as a deduction, or any amount has not been included in your total, Meaning either it was given as an exemption, maybe under section 47, where it is not regarded as transfer for the purpose of levy of capital gains tax. Or some amount would have been allowed in deduction, maybe under 36(1)(a), 10(AA), all these. Either upon fulfillment of some conditions or otherwise. Some deduction is given, some exemption is given. If this old act had not been repealed, the amount that was allowed as a deduction or amount that was not included in the total income were to be charged to tax in a tax year subsequently, had the Income Tax Act of 1961 not been repealed, such amount in such subsequent tax year should be deemed to be an income and it will be included in the total income. I'll give you an example. 10AA, Special Economic Zone, a reserve is created. You get 15 years tax holiday. First 5 years 100%, next 5 years 50%, and another 50% subject to creation of reserve. In the last 5 years, only upon creation of the reserve. And there is a condition as to how the amount of the reserve will have to be used. This is a breach of condition. So the breach of condition, then it will be charged to tax. This is one situation. Take another situation of 36(1)(a). If you are a banking company or a public financial institution or a cooperative bank, you are permitted to create a special reserve and you can transfer 20% of the business profit to the reserve and you will allow a deduction. In whichever year you withdraw, it will be charged to tax. It's not a violation of condition, just that it will be charged to tax in the year of withdrawal, it will help you defer the tax. So they would want these things to be charged to tax. Take the case of bad debt recovery. You have had the bad debt deduction law, recovery takes place now, would be addressed here. Very well thought out provision, but look at the goof of the other. Now read this carefully. Such sum, look at from the fourth line, and such sum was required to be included in the total income of the subsequent tax year, including beginning on or after 2026 under the repealed Income Tax Act. So it should have been charged to tax in a subsequent tax year under the repealed Income Tax Act. Here be careful. Do we have the phrase called tax year in the repealed Income Tax Act? We don't have. How do you apply this? It uses assessment year and previous year. I have 526(3) which will construe reference to tax period as previous year. I don't have a reverse. Now, where does the repealed act provide that this has to be charged to tax in a tax year, because the word tax year is alien to repealed act? Could you not have addressed this? They could have only stated that any subsequent year, that would have been enough, which would have fallen into some tax year, some assessment year. So use the phrase tax year with reference to repealed Income Tax Act, which never ever recognized tax year. So therefore it will even fail down. Unless and until they amend this. So some of the provisions, like which would possibly hit you on this could be, as I said earlier, capital gains benefit which you get under 54 if you have put it in the deposit, you end up not utilizing it, and at a period of 3 years when it will actually fall in the new regime, you get hit by this clause, you get taxed. So violation of 54F condition, 54EC lock-in, which is like breach, 11 to 11.3 you accumulated and you are expected to utilize it for the purpose of charity within 5 years. If you don't, then you get hit by this provision. And 10AA, section 41, all these have been already dealt with. Clause I is similar to 297(2), which states that the sum payable under the repealed Income Tax Act may be recovered under this Act. What was payable under repealed Income Tax Act? That means before its repeal, it had become already payable, but not yet recovered. It could be now recovered under this act. So this is one such provision that needs to be noted. 536(2)(j) is a very interesting section. It says, any agreement entered into, any approval given, like charity approval, recognition, etc., circular directions, instructions, notifications, order, rule, scheme, framed therein under any provision of the repealed act, insofar as it is not inconsistent with the new act, shall be deemed to have been made, granted, issued under the new act. Okay. Whatever made under old act shall be deemed to have been given in the new act. So this was not required. Why is it not required? Section 24 of the General Clauses Act already would be in it. As I said earlier, whatever notification issued, whatever rule issued under the repealed act would continue to apply in the context of new act. It would apply. So they should have allowed it to operate. Instead, they have had a separate provision. So what will be difficult? Because you have a separate provision, 24 would not apply. So what will happen? You have income tax rules of 1962 plus a big set of rules. Correct? Now you have income tax rules of 2026, another set of parallel rules, both will operate. If this clause were not there, section 24 of the General Clauses Act, what it would have said is, till you make a new set of rules, the old rules would apply, and as soon as you make a new set of rules, the old rules will go. Now you have a very funny situation of both sets of rules being applicable to you, and whichever would adopt, left to myself or adopt whichever is favorable to you. Now take the double taxation avoidance agreements that you have entered into. These agreements would have been entered into under which section? Section 90. Now, which is the parallel section in the 2025 Act? 159. Now, because of this, all these agreements are now deemed to have been entered into under section 159. However, the notifications have been issued for each of those double taxation avoidance agreements. Right? This is what the Honorable Supreme Court said in Nestle's case. That whenever you amend the agreement, whenever you issue a protocol or an MFN clause, unless and until a notification is issued, which is with due respect to Honorable Supreme Court, it's an incorrect interpretation. There is no need for issue of a notification at all because it's an executive action already sanctioned by the legislative sanction of section 90. Whatever it will leave the top now to become law of land, that every setting will have to be notified. Now, you have section 90 agreements. 90 plus agreements have been entered into under section 90. All these are now deemed to have been entered into under 159. But would that mean the notifications issued thereunder are deemed to have been issued? In one way, notifications issued under section 90 in respect of these 90 plus agreements may have been deemed to be issued under section 159, but it is too far-fetched to say that they are deemed to have been issued in respect of agreements which are deemed to have been entered into. Now, multiple fictions may not be permitted, but don't ever utter this anywhere. The department would be too pleased to have this to kill all the double taxation avoidance agreements. To say that we will apply in Nestle's case, all these DTAs will now go. Let's not do that. I think I have some more clauses which I think already taken now. 10 minutes beyond my time. In another given occasion, we will discuss this. Suffice at this point in time for us to know that this is a very complex section. It would still have clauses up to V, which we'll have to look at. A lot of interesting things are there to discuss in the context of clauses M and N, which will deal with carry forward and set up of laws. The legacy issues in the context of amalgamation. When you should do the amalgamation, what should be the appointed date, where are you deprived of, like the benefit of section 72A. A lot of things do arise, but make sure that you go through all of this carefully, apply your mind, and then take a position. So with this, I would thank the Bangalore branch and I thank you all for having very patiently heard me. And all the very best in the new 2025 regime.
sure it was very knowledgeable and insightful. And the first session for this, from dream to practice, has been perfectly started with the transition process by Advocate K.K. Chythanya sir. I request C.A. Kavita Parmesh, please do come on the dais and hand over a memento for Chythanya sir. Can we have a round of applause for? Thank you so much, sir, for sparing your time for the knowledge session that was happening today.
Good evening, everyone. Thank you, Bangalore branch, for giving me this opportunity to come back here and share my thoughts about income from salary, the changes that the Income Tax Act 2025 brings in into income from salary. After Chythanya sir's session, talking is both easy and difficult. It's easy because he's already put you onto the journey of learning. He's already taken you to a pinnacle, so it makes it easy for me to connect from there and carry on. It becomes difficult because the standard is set so high already. Anything I do cannot definitely match up to that. So it becomes both easy and difficult. I'll try my best to do what I can. I've been asked to cover two things. One is what are the changes that may impact which have happened in the definitions. So these are the three things that I intend to cover. The first one I don't intend to go in detail, which is about the legislative intent and overview. You've heard the people from department speak about this. There's nothing new that I will be talking. I've mentioned here, just borrowed from what government has been saying without being judgmental about it. Then I'll be speaking about what are the key changes that have happened in the definitions. Some of them have not covered all of them. Some key definitional changes I have covered. What are the changes from a standpoint of income from salary? Firstly, this is known to all. After 64 years, the changes happened. The IT Act 1961 replaced by 2025. Four broad structural changes. Number one, there are no provisos and explanation as of now. So that is it's a rider. As of now, there are no provisos and explanations. I'm curious to see how they will make amendments in the future. Will they change the section itself? Because Finance Act is a reality that our lives have had in the past. It's going to be there in the future as well. And each Finance Act will necessarily bring in amendments. So in the future, will the amendments which are clarificatory in nature, which are deeming in nature, which goes back in retrospect, how will they make all these changes? I'm curious to see. Because now the claim is that there are no provisos and explanation, which is true as of now. This is the other headline change. There is no word, no non-obstant clause anymore. It is irrespective clause which has come in. Tables and formulae. The entire law is now tables and formulae. What used to be long description of how a formula has to work is now mathematically represented. What used to be told in sentences are now in the form of tables. How easy, difficult? I think during the course of this journey of learning Income Tax Act 2025, we will all figure that out. Last thing is there's a continuous numbering. There are no intermittent numbering now. There's nothing called 1023C, things like this. They are all a straightforward numbering. Again, is this going to be short-lived, only 1 year? Will it happen that when the change is made in the next year, will it come back? Not too sure. So these are some statistics. 819 sections have become 536 sections. 50% reduction in word count. Again, statistical number, nice to know. From Chythanya sir's session, you already understood that that means nothing actually. Just by reducing the words, nothing takes place. 57 plus tables and 46 plus mathematically explained formula given in the income tax law. Will it reduce litigation? Time has to tell. We all have a lot to do in future. Our careers are safe, so nothing to worry about that. No AI can take away our careers as well. So what are some of the changes that have happened in the definitions? Again, this is something we already saw. The word previous year and assessment year is now replaced with tax year. Section 3, which used to speak about previous year earlier, continues to be the section for the definition of tax year. the word assessment year has been removed. So there is no more reference to assessment year. Tax year, like we all understand now, is a year of 12 months commencing from 1st of April and ending on 31st of March. In case it's a business which commenced during the year, profession which started during the year, from the date of commencement of business or commencement of that profession till the end of 31st March is what is going to be called as the tax year. What continues while the two concepts of tax year, previous year, assessment year goes away, earning the year in the tax year and its real tax payout in the subsequent year continues. So fundamentally nothing changes. But describing it by 2 years, which is a previous year and an assessment year, now goes away. It's going to be one tax year. The word assessment, earlier defined under section 2 bracket 8, used to say assessment includes reassessment. Now it says it includes recomputation as well. Is this something new? From a legislative standpoint, definitely it's new. The word includes recomputation was not there in the law. Now in section 213 it has been brought in. But judicially it was always held so. So there are two of the landmark judgments on this matter I have noted here. Kalavati Devi Harlalka judgment of Supreme Court and C.A. Abraham versus ITO judgments, very old. So you can see these are 1961 and 67 judgments. Pretty much since the Act has been there, this was always meant to include assessments, to include recomputation, reassessments, everything was a part of it. So now they have codified it in the law itself, whereby they have defined it as a part of the word assessments. This is a new change that have happened. The word charitable purpose was earlier defined under section 2 bracket 15. What did it say? You can see the first table. It says that these were the things which were called as charitable purposes: relief of poor, education, yoga, medical relief, environment protection, monumental protection, and objects of other general public utility. Now 2 bracket 23 continues to have the same things. There is no change in this. But what has changed? What has changed is, earlier there was an explanation to 2 bracket 15 which said that in case the objects are of general public utility and if it has to continue to be called as charitable purpose, two conditions were there. One, the receipts from such business activity that they may carry out cannot be in excess of 20%, and such activity should be ancillary to the main activity of being charitable. So these were the two things that were there in the definition itself as a part of the explanation. Now they have moved this away from the definition. Now charitable purpose definition does not include these conditions. So what am I trying to say? I am trying to say that earlier if a charitable institution, let's take a trust for example, had an object of general public utility which continues to be even now there is no change. Even objects of general public utility can be considered as charitable purpose. But earlier the definition had these two clauses which said that any business receipts that may happen from such objects of general public utility first should be ancillary to the charitable purpose. Second, cannot exceed 20% of the gross receipts. Now they have moved this out into a different section. They have moved it into a different section, section 346, where this has been written in detail, exactly same, but they have added one more thing. They have said that as a part of it, maintaining separate books of accounts is henceforth, hitherto which was not there under at least this definition. It used to be there in section 11. It used to state that you should maintain separate books of accounts under section 11 where the exemption was being given. Now there is a separate section carved out under the chapter of non-profit organizations where it is said that the three conditions are there now, which is number one, like I said, it should be ancillary. Number two, 20% test. Number three, separate books of accounts have to be maintained. So basically what used to be in different places have now been combined. Will it have a larger implication beyond what we are imagining now? I at least could not put my mind towards understanding what larger implications could be there, other than the fact that now there is no definition problem. Under the definition, this is not a problem, but this lays down a separate condition under a separate section. Next, the definition of books of accounts. Section 212A of the old Act, ITA 1961, had the definition of books of accounts. In this, what were covered? Records kept in written, electronic, digital or printouts of electronically stored data, including electromagnetic device such as floppy disks and tapes. These were considered as books of accounts. Now they have added the word cloud storage. So what used to be, put your mind into this, that till now under the ITA 1961, what used to be stored in cloud storage was never considered books of accounts. So that ambiguity existed, though cloud storage had become a reality at least 10 years, now, AWS, Azure, etc. have become a reality for almost 10 plus years now and has come to accounting softwares also, but they were never considered books of accounts. So that is one thing that has been plugged. And the more interesting part, when I went back and read it, though we had read this before, the fact that digital forms were only added in 2022. Right? So imagine the speed at which things have changed on ground and the speed at which income tax law has been changing. The tectonic shift in the speed at which the technology is evolving, income tax law has not been evolving. This is definitely a good move. Avoids unnecessary confusions. So because we have a few clients who have cloud storage which are globally taken. Their Indian subsidiaries use the same cloud storage, were using the same cloud storage. Then Companies Act made it mandatory that you need to have servers which are located in India for books of accounts to be in India. Now it has also been included in the tax audit report, the new forms, that you have to specify where the books of accounts are maintained. Now for that reason, this becomes all the more important to know that now cloud storage is also permitted as one of the modes in which your books of accounts can be kept. The definition of relative. So what was happening in section 241? Relative was defined as, relative means husband, wife, brother, sister, any lineal ascendant or descendant of the individual. This was the definition that was there. The relative definition for other law, say income from other sources, it had a different definition. If you look at 288, definition of accountant, there is a definition of relative again. That had a different definition altogether. To some extent they were all aligning, but they had differences in itself. Now what has happened, they have clarified that the lineal ascendant-descendant includes both paternal and maternal ascendants and descendants. This clarity never existed in the earlier definition. So till now the interpretation was that it was only paternal descendants and ascendants which were covered under the relative definition. Now because of this inclusion, it even includes maternal. Why was it left out? Why is it added now? I am not sure. I would think that lineal ascendant-descendant should have included both paternal and maternal always, but it was not so. It was only interpreted to mean paternal. Now the maternal ascendants and descendants have also been included. The same inclusion, same clarification has also been made in the respective definitions for income from other sources as well as all other places where it is there. Therefore, you may think that why is the section 294 really required? But there are still certain provisions in the law where the word relative is not being defined under that respective clause. For example, the old section 40A2, where you are testing whether the payment made to a specified person, whether it is commensurate with the market standards, etc. In that, for an individual, they say a relative of an individual is a specified person. In that section, the word relative has not been defined. It is left open. In such cases where the word relative has not been defined, you will now have to, you were always referring to the old 241, now you refer to 294, which includes both maternal ascendants and paternal ascendants and descendants. So these were are some of the critical things that I noticed as far as changes in the definitions are concerned. Most of the other definitions, what has now happened is that what used to be included the majority in section 2 have now to some extent been distributed, but in effect remains the same in its application. So there are not many changes from an applicational standpoint. These are some of the important definitional changes that I wanted to highlight. I'll pause here. If any questions I'll take on this, and I'll move to income from salaries. Okay, moving on. Ideally, income from salary was a very set, or there was not much happening in this chapter under the old law, except for litigation around ESOP, timing of taxation, the judgment of the Bangalore Tribunal on taxing a reduction in the value and compensation by employees. These were some of the things that were getting litigated, and the salary chapter was for quite some time a silent one under the 1961 Act. Now, there were draft rules that are available in February 2026 also. Even till then, this was a very silent chapter. This was not supposed to make a lot of noise. Now what suddenly has happened is that the section itself, or the chapter of salary itself, is not making so much noise, not making too much change, but for one or two changes which I will be highlighting, the rules have actually brought this section back into some kind of a interesting situation. Firstly, like I said, it is a very cosmetic change. Distribution, consolidation, removal of provisos, removal of explanation, same things are continuing here. Like I said, the Act gave the skeleton, the rules gave the flesh. So that is what has been happening right now, which I will try to highlight. Old regime is suddenly pivoting. So the old regime, which for in majority cases seemed extinguished, dead, not anymore relevant, suddenly comes into life in certain peculiar and particular situations. So, and this in the context of new labor code that has come in, which I will be just touching upon in the end to make sure that this is comprehensive, though I don't intend to go into detail of that. You will understand why old regime has again become, got into life and is pivoting. Broadly, in terms of the structure, this is a comparison between the old Act and the new Act. The basis of charge continues to be section 15 in both the laws. The charge itself remains the same, which is earlier of due or paid. This is how it was in the old law, continues to be in the new law as well. Source rule, which is accrual in India, section 9. When is an income from salary set to accrue in India? If it is earned in India. This is what the section 9(1)(2) spoke about earlier. Section 9(3) tells you the same thing, but there is again that change which has come in from a standpoint of removal of explanation. Earlier there was an explanation telling what is earned in India. Now that has been made as sub-bullets under earned in India, under the clause itself under 9(3), and the same thing has been explained over there. Definition of salary was in section 17(1), now it is in section 16. Again, no categorical change here. What used to be a consolidated line have now been split. Commission, remuneration, etc. were to be in one clause, they have just divided it into multiple sub-items, so no change over there as well. Definition of perquisite, 17(2), and valuation of it was in Rule 3. Now there is a section 17 is fully dedicated to perquisites right now. 17(3) had profit in lieu of salary, it has moved into a different section. So again a very cosmetic change, nothing much changing over there. Rule, what used to be one rule, Rule 3, are now different rules, Rule 15 to 18. I have spoken about some of these aspects in the subsequent slides, I will talk to you about that. Like I said, profit in lieu of salary, 17(3) has become a separate section, section 18. Now this is a major change what has happened. Earlier there were only two deductions from salary. Section 16.1 and 16.2. There were two deductions. 16.3. There were two deductions. Now there are multiple deductions from salary under section 19. So what are those? I will explain to you. That's a very surprising move. Again, I was just talking to Chythanya sir in the break. We are trying to figure out why this has happened. Not really very sure, but they have done this. That is the next change which I have spoken about: gratuity, commuted pension leave, and all. I'll go into detail about it at that point in time. HRA used to be under section 10. 10.13A, and leave travel allowance, leave travel concession used to be under 10.5. Now they are no more in the Act, as in the main sections. They are being moved into a schedule, and the detail of that are there in the rules. There is a schedule 3, serial number 11 and 8 particularly. So this is what I kind of find it difficult now. So now you have to remember the schedule, the table number, and the serial number in that table number. Now, how did it change from us remembering section, subsection, subclause? I don't understand. It to me remains very similar, but now navigating is a lot more easier, maybe because it is initial days, but I don't see too much of a change that got achieved by doing all of this. TDS on salary 192, now it is in 392 under a consolidated chapter. Some of the important rules and forms, corresponding comparison between them. Valuation of perquisite, like I said, it was in Rule 3, it's now in Rule 15 to 18. HRA exemption was in Rule 2A, now it is in Rule 279. What I had thought, how the income tax rules 1962 were, it had followed a sequence of income from salary, income from house property. The rules were also in similar sequence. Now what has happened, because in income from salary and income not included in the total income, that is exempt incomes, now they become schedules and they are at the end of the Act. Because it is at the end of the Act, the rules relating to this have moved to the end of the rules. So this is what is one major shift that has happened. Otherwise Rule 2BB had allowances, Rule 3 had perquisites. Now they have all moved into the end of the rules. So that again is the cosmetic change that I am talking about here. This I put it out here for you all to navigate it easily so that you don't have to keep searching. So I put this here. Rule 2B has become 278, which is the leave travel concession exemption conditions. TDS return 24Q has become 138. Don't ask me question on 138. I have not yet looked at them, not yet filed them. I'm sure none of you have as well. We will figure that out. Like sir was mentioning earlier, as we start filling the forms, there will be multiple more things that will come out because of one simple thing a developer does, which is they make some field mandatory. The moment a developer makes a field mandatory, we are all victims to it. So one hue and cry happened, TIN number in case of let's say form 145, 146, which used to be 15C and 15CB, TIN number they made mandatory. Now that is a small change from a developer standpoint who is developing those forms. It's a small change. They just made that form mandatory. But what it creates for all of us who have been using those forms maybe for the last 10-12 years, this data would have never been captured at that point. That is never the point of capturing a TIN number of a foreign recipient of remittance. Now suddenly you will have to start grappling with the fact that you have to gather their TIN number. There may be people who might not want to share their TIN number because in certain countries outside India, TIN number is highly protected. That is the same as social security number. So that's a common number. So they don't want to reveal it just like that. They are scared that that number is now going to the Indian Income Tax Authority. All of these, right? So challenges come up. But what happened? One developer who was developing the forms just marked that field as mandatory. Now, was it intentional, unintentional? I am not sure. Next on TDS certificates, what used to be Form 16 will now be called Form 130. Again, for its use at the end of this financial year, they are going to use it at the end of 26-27. 26-27. Perquisite annexure which used to be there along with Form 1612 BA is now become 123. Taking those declarations from the employee used to be 12 BB, it has become 124. Yeah. So this is what I was talking about, one structural change that has happened in this chapter. There used to be quite a few exemptions that were there, particularly these 5: gratuity, commuted pension, leave encashment, retrenchment compensation, and DRS compensation received during DRS. What used to happen under section 10, there are different subsections where they were not even considered part of the total income. That is how the law existed all these years. Now what they have done, the new section 11 is the old section 10, which is income not forming part of the total income, and there is a schedule to it. There is a schedule 3. Earlier the section 10 used to be a long section, now it has been shortened, there is a section 11, and all the details are in schedule 3. Now, from that schedule 3, these 5 things they have removed. So it gives an impression suddenly that is gratuity taxable, is DRS compensation taxable, etc. The answer is no. What they have done, they have added it in section 19, which is a deduction section. Now an exemption item moves into a deduction. So that means it is primarily taxable. And I also noticed that they have added these in section 249, which is the definition of income. What used to be 224 earlier is now 249. They have added this in the definition of income, and they have made it as a taxable income and then given deduction under section 19. That is how the new change has happened. If you look at the general used case, this changes nothing. It used to be exempt, now you get a deduction. Now what it could mean? It could mean that tomorrow those deductions can be trimmed down. Now they have already made an amendment to include that into income. Will they remove these deductions under the new regime? Not sure. I am speculating, right? So I am not telling you what has happened, but the possibilities are that in section 19 they can, in 202, which is the new 115 BAB, you can actually say that these deductions are not available for it. So it becomes a little more easier from a construct standpoint to do that change. That could be one reason why they have done it. I couldn't otherwise think what could be the reason for making this change. The remaining sections relevant to the salary head, which is the contribution into various funds, HRA, LTC, those continue to be there. Covered under section 11, but moved into different schedules in the form of a tabular manner. Those schedules have given you what are the conditions, when is it applicable, nearly identical to what used to exist so far. There is no great change that has happened in this. This is another very interesting thing. Now, let's assume an employer is giving a cab facility for employees to travel from home to office. Under the old law, section 17(2) had a particular provision where it said that if the employer is giving a facility for travel from home to office and back, that facility is not considered to be perquisite and therefore not taxable. Mind you, this is not transport allowance, conveyance allowance or anything like that. I am not talking about an allowance which is part of the CTC. This is a situation where a cab facility is given. If this section were not to be present, it would have been taxable. Because that was there in the law, it was not taxable. In this, the condition was that that facility is being provided by the employer. Now what they have done is, they changed it to say that any expenditure incurred by the employer for the use of any vehicle for journey. That means, even if an employee incurs an expenditure for travel from home to office and back, and a reimbursement towards that is made, the moment it is a reimbursement, it is expenditure incurred by the employer, even then possibly this could be exempt. Now does this allow employers to plan something using this provision? Is for all of us to think, but one has to understand that if they are already giving conveyance allowance as a part of CTC, can these two coexist with each other? if you give it as a, can you claim conveyance allowance to be exempt, this also as exempt. These are the things that will become challenging. Again, why am I talking about conveyance allowance and all of that? Though you may all say, why are you talking about it, because they are anyway not applicable. They are being made applicable as exemptions under the new regime as well now. So that makes it more interesting. One may choose new regime. After that, there are some winners. These kind of components, we internally call it as double winners and triple winners. So we are saying double winners are there where old regime, new regime, they are exempt. But under labor law, there is a difficulty. Triple winners are where in all the three there is a favorable position. So there are items like that. It is worthwhile to consider. May not be so much of a tax impact for employees. When I go to the new labor code related, you will understand, if the salary structures are not replanned by employers, the gratuity liability would significantly go up. Number one. Number two, if provident fund was being calculated on basic plus HRA plus whatever, basic and HRA, let's assume till now, or only on basic till now. Now, under the new labor code, there is a unified definition of the word wage. And imagine a situation where an employer has not capped the PF to 12% of 15,000, they are giving it on the entire basic. The take home of employee will significantly drop down if the components of the salaries are not replanned, considering both new labor code as well as the income tax rules that have changed out of this. So this is what I wanted to tell. There was one judgment in the Gujarat High Court Reliance Industries. This was a case where the department did a TDS survey. In the TDS survey, they picked up two items. One item was this CAP facility that was being given. Second item was Sodexo coupons that were being given. And they wanted to call the employer as SSC in default for not complying with the required rules. In that judgment, it was categorically held that the travel from home to office and office to home cannot be considered as a perquisite. This was a judgment which existed under the old law. Now, because of the fact that it's no more required that the employer gives that facility, the expenditures can also be reimbursed. You can take a decision if this will change any facts in any of your clients' cases. Yes, sir, you seem to have a question.
See, one of the most used methods is self-lease of the vehicle to the company, getting that the increase, no doubt an expenditure incurred by the company, paid to sell for somebody else, and the vehicle is used for performing, for going to the office and coming back. Now this is, and is there any purchase value like the old 1,800, 2,100, that is not there now. See, it doesn't amount to a purchase. It is non-taxable. And whether he offers to tax or not tax, whether TDS is a different issue. Can the employer, that is under new this Act, 2025 Act, can the employers restructure in such a way that they keep on paying the vehicle charges and keep reducing the taxable side?
Okay. So, let us get the facts once correctly, sir. Let's assume there is a lease of a car, but when you say lease, is it rental or is it a
self-lease? I own a car, company doesn't have it, I lease it out and they pay me car lease, I have charges at the rate of 50,000 per month, something like that.
Identical to the old law, sir. There is no change as far as this is concerned under the new law. But there is one change that has happened as far as car running expenses reimbursement is concerned. I have captured that. If it still doesn't answer your question, we will discuss this at our times. When we go to that, I have that.
Try to get your answer.
So my answer is, the provisions which existed in the old law, new law, as far as that lease is concerned, is identical. There is no change.
But here there is a separate exemption section itself, which was not there earlier.
Correct, sir. So I will go to that. That's what the reimbursement of car running expenses. What change has happened? I have captured it. In case it doesn't answer your question, the fact pattern, we will discuss that again.
Incidentally, you should also address where the company takes the car on EMI basis from some company basis, but the vehicle is
that I will address. So what is happening? Let's assume somebody's cost to company is 50 lakh rupees. CTC agreed with an employee 50 lakh rupees. The employee negotiate to state that, hey look, buy a car, take a loan on that car, the EMI, let's say, comes to 30,000 rupees a month. So what the employer-employee currently do is that 3,60,000 rupees, they directly reduce it from the 50 lakh CTC. So they make it 46,40,000. And this car is separately bought in the name of the company, loan taken in the name of the company, only exclusively available for the employee to use that car. On top of that, because the car is owned by the company and the expenditure towards that, let's assume two possibilities. One, the employer are paying for the fuel, for the insurance, etc. Or they are recovering it from the employee. Let's take two scenarios. One scenario where the employer only is incurring the expenditure. In the car running and expense reimbursement perquisite valuation, they have a perquisite for that. There is a reduced value 5,000 rupees. I have captured that 1.6 cubic capacity, 1.6 liter cubic capacity and less and more. There is a perquisite that has to be added. In case the expenditure is met by the employee and reimbursed by the employer, so then reimbursement minus the value that has been given is considered perquisite. So two kinds. When the employer bears it, that value itself is perquisite. It's 5,000 rupees perquisite. In case when the employee incurs it, reimbursement is, let's say, 10,000 rupees. 5,000 is exempt. 5,000 is taxable. This is what is there. This is one of the methods in which the employer-employees plan. It continues to allow even under the new rules. So there is no change as far as that is concerned. What has changed, like Sir was talking about, is under the new regime. In the old law, under the new regime, this valuation of perquisite, making them exempt, etc. were not there. Now, in the new law, in the section 2022, which talks about what all cannot be reduced for computing the income, in that the reference to this perquisite valuation section and schedule and table is not there. So then what happens? Let's assume that the salary component has certain perquisites in the form of car running expense reimbursement, Sodexo coupons, gift vouchers, I've spoken about all of this later, or reimbursement of telephone and mobile charges. See, these are there as a part of the salary component. Because in the new regime they have not excluded the reduction from all of this, you get to actually plan it, thereby these are all exempt and then you can compute the tax on it. Therefore, I was trying to tell that the rules have actually made this chapter what it is, and you have to look at it in concurrence with the new labor code as well. So this is the points. So did I answer your question on this?
Partly.
Okay. The other part, once I finish that, if it is still there, I will talk about it. So some of these allowances, the exemption limits have been sharply increased. HRA again only available in the old regime. What used to be 2A is now 279. The 50% benefit, what used to be there only for 4 metro cities, now 4 more cities including Bangalore has been added. Bangalore, Ahmedabad, Pune and Hyderabad are added into it. Form 124, where you collect the details for allowances, perquisite, etc. Now there is a new clause added over there. This was widely reported in newspapers and all of that also. Now the employees have to declare their relationship with the landlord. So all the planning that was being done where children are giving rent to parents, spouse, etc. Now that gets reported. Now does the employer have, so one of the clients for whom we were restructuring, so they were asking that should we take any cognizance of that, should we audit whether the rent is being actually paid and all of that. So I told them that look, as of now there is nothing. The circular on TDS, annually the circular that comes out has not yet come out. Typically it comes out in November, December every year. So you have to do TDS every month, but the circular relating to that comes out almost at the end of the financial year every year. Now will they put in some obligation in that circular? I am not sure. But as of now, there is no such obligation. 124 form you have to take whether if the landlord is related, yes, no, what is the relationship. The employers have to collect. Most of the standard payroll tools that are available have already populated these forms. So the companies which have implemented that will already be doing that. Leave travel concession, what used to be Rule 2B is now Rule 278. There's only one change in this that has happened. Different modes of travel, air travel, there is shortest travel, whatever class, economy class, etc. So that is there. In case the travel is through train, what is the exemption? Continues to be same. What if the travel was not in a public transport? And two possibilities. One, public transport is available, public transport is not available. These are the two things that are there, they continue to be there. In cases where there is a travel and public transport is not available or is available, but you travel through a private transport, then the value is equivalent to the railway ticket. That is what existed under the old rules, that is what continues to be in the new rules. When no public transport to that that place exists, then the old law also made it, if it were to be a travel in train for similar distance, similar short distance, etc. Now they have fixed a limit saying 30 rupees per kilometer is the value that can be considered as exempt. How did they derive at 30 rupees per kilometer? I am not sure, but this has been introduced into the rules currently. So let me summarize it again. In case there is a leave travel allowance component, an employee is under the old regime, they want to claim an exemption under the law for the leave travel allowance. The travel is to a place where there is no public transport available, therefore the employee and his family travel through a private transport. The exemption that is available for leave travel allowance is 30 rupees per kilometer. This is the only additional thing that has happened. Again, highly restrictive. If somebody is following old regime, only for them this is going to be applicable. Children education and hostel allowance, when the old regime was live and kicking, every year in the recommendations to the ministry it used to go, they never made this amendment despite the increase in the cost of education and hostel. Now when the new regime has become a default regime for the last period, new act has come in, they suddenly increased this limit. And that too it benefits only the old regime. Now what is the logic behind it? Again, not sure. So maybe these rules were drafted and kept, suddenly somebody released it without reading it, is what it looks like. Otherwise, increasing it from a 300 rupee to a 9,000 rupee, 100 rupee to a 3,000 rupee, when most people were following old regime or old regime was the only regime, this kind of an increase should have been made, but now it has been made which benefits only the old regime. Given all of these, there could be certain income brackets, salaries particularly, for whom old regime may become beneficial. What? Because of the slabs and tax rate differences, now new regime was nearly maybe 90+%. That is what the statistics of the government say, that people were following the new regime. Now possibly a small percentage may shift over to old regime if these components are there in the salary. Worthwhile to analyze in companies where there are large number of employees in a certain salary bracket for whom these kind of things may become beneficial. Transport allowance, this existed in the previous law also for a Divyang employee. So now this exemption is available both under the old regime and new regime. So this is what I was talking to in response to Sir's question on motor car perquisite. So this is called car running and maintenance expenses reimbursement. The limits have increased. So what are the different cases? First case, employer owns the car. It's used for, when the employer owns it or employee owns it, 100% used for official purpose, fully exempt provided the logbook is maintained. This is the clear position which existed earlier, continues now. If employee owns it, fully for personal use, taxable. So this doesn't change. There is no change in this. What has changed? If employer owns the car, it's partially used for official purpose, partially for personal purpose, then what the perquisite value, the values that you see in the first part of the table, 1800 rupee used to be the perquisite value. Now the perquisite value has become 5000 rupee. That means, if in the example that we discussed, which is employer owns the car, gives it for use to the employee, that is, they have leased it, gives it to the use by the employee. Perquisite used to be 1,800 rupees per month, now the perquisite value increases to 5,000 rupees per month. This is the first change. This is in case where the engine capacity is less than 1.6 liter. If it is more, what used to be 2,400 now has become 7,000. The value of perquisite increases. 3,000 extra for chauffeur is also given. If a driver is given, the value of perquisite increases by 3,000. Next category is employer owns the car, used for partially official purpose, partially personal purposes. Employee bears the cost and reimbursed by the company. Car is owned by the company, employee bears the cost, expenses are reimbursed by the company. The perquisite values were substantially lesser, 600 and 900 respectively, now has gone up to 2,000 and 3,000 per month. Mind you, this is the value of the perquisite itself, because what is the perk here? The perk here is the car. And since this is owned by the employer, the value is for the car that is being given. And value of the perquisite are as stated here. Now in the next situation, which is when the vehicle is owned by the employee and expenses to maintain that car, run that car in the form of fuel bills, driver's salary are reimbursed by the employer, the 1,800 and 2,400 used to be the exemption. That is, if let's say 10,000 rupee per month is reimbursed towards fuel bills and the car is owned by me, I am an employee, 10,000 minus 1,800 used to be value of perquisite. 1,800 rupee exemption was there. Now that exemption moves up to 5,000 and 7,000 respectively for less than 1.6 liter and more than 1.6 liter. Now in the case which Sir said, which is I own the car, I lease it to the company, company takes it on a lease, gives it back to me to use. Now, in my view, it should fit into the third category, which is owned by the employee. Because company has leased it, does it change anything? It should not, is my view. Now have I answered you fully, sir?
Can I have the mic?
Yes.
The mic. See. Please do not mix up the chargeability to tax as the salaries versus the perquisite value. My CTC say is 1 crore. 24 lakhs, 2 lakhs per month is spent for the vehicle, purchase of vehicle, something motor car expenditure. 1 crore minus 24 lakhs is 17 lakhs.
76 lakhs.
Now, no doubt that 24 lakhs is spent by the company on commuting, which is exempt under 17(2).
Correct.
Okay. Now, in Form 16, new form, I am supposed to say total salary 1 crore, let's say 24 lakhs, and add perquisite.
So this is precisely the reason why employers have been structuring it in such a way that the vehicle itself is bought by the company and the loan on that is taken by the company. They exclude it from the salary computation itself. It is not, salary is not even declared as 1 crore, it is declared as 76 lakh. In that case, the 24 lakh is not even part of the salary. It's not even part of the income.
See, it comes under 17(2). Therefore, it is nothing in subsection shall apply to 17(1). Therefore, actually it should be 1 crore minus 24 lakhs, add perquisite value, then it becomes a net amount.
Sir, in case the car is owned by the employer.
Whatever it is, there is an expenditure incurred by the company. Don't worry whether it is a third party car, his car, or leased car.
They are different, sir. That is why I am saying.
And no, that is not required for the purpose of perquisite calculation.
Correct.
I am actually coming to the question of determining the expenditure. There is an expenditure no doubt incurred by the company. I am using it, and you calculate the perquisite value based on ratio, sharing, everything doesn't matter.
Correct.
Now, if my CTC were to be 1 crore, 24 lakhs is the car expenditure incurred by the company. Okay, component parts of it, forget about it. I am supposed to say gross salary 1 crore, expenditure not included under 17(2) is 24 lakhs. add perquisite value, then come to the net amount, or simply start with 76.
So currently the practice is starting at 76. That is the practice. That is what.
How correct it is.
Yeah. So.
Employer is saying the responsibility of declaring that his salary is 76.
Correct. That is what as the employers are taking the view right now, and 76 is being declared as the salary itself. That is what is being done currently. Now, how correct is that? Technically speaking, first it is salary. Then there is an exemption to it. So, you are absolutely right to say that 1 crore should be the value of the salary, minus 24 lakh should be reduced, and then if any perquisite value is to be added back and computed. But that is not how it is being structured. It is being structured whereby the promise is not being made by the employer in the offer letter to say that I will give this car to you. It is being generally given as a part of that particular grade of employment, and they are not even considering it as a part of the salary. This is the way it is being done currently.
I am not actually checking how it is being practiced. There is an offer letter saying that your salary is 1 crore.
No, if there is an offer letter saying 1 crore, then I am absolutely.
Therefore,
sir, they are not doing that, which is what I am saying.
Initially, it starts with the employment offer letter.
Correct.
Previous salary is so much, I am giving this increment, and the 1 crore is this, the component parts of it is like this.
Correct.
Therefore, starting with offer letter, the employer cannot say that his salary is 1 crore.
Absolutely. If they say that, there is no ambiguity, sir.
And he has to take the letter under 17.2.
Correct.
When the 17.2 gives clear exemption of the expenditure incurred for committing the department cannot do it.
Correct. So now what they are doing to be double safe about it, they are not even giving it in the offer letter of 1 crore, the offer letter says 76 lakh. That is what is being done. So they are not even getting into the debate of whether 17.2 and the old 17.13 applies
As
or
I
not.
said, I am not actually checking the practice.
Ah.
I am checking on the legality of
Legality
being
of
done.
sir, that's what, sir, in the legality of it, if the offer letter itself says 76 lakh and not 1 crore, now where is the question of dealing
Now,
1
if
crore?
offer letter says 76 and then he incurs the expenditure,
Ah.
that doesn't enter that one.
Correct.
It doesn't come to 17.2.
Exactly.
I am actually going back and reworking the cases where 17.2 can be availed of.
Correct. If the offer letter says 1 crore,
Now, offer letter, I am already in employment 10 years back, it is there. Now, on the basis of ITI
then it is
2025, I
abusing.
want to take
Then it
17.2.
is abusing, right, sir? So,
No, it may be abused, but they have only provided the exemption. No?
so they have provided an exemption for travel between home to office and back.
I understand, okay, see, if it is completely personal, that is determined by the perquisite value.
Correct. So that is
Okay,
the-
there is a computation mechanism for that part of it.
Correct.
But
So there are 3
17.2,
things here, sir. One is commute between home and office and back. This is the first thing. Second, completely for personal use. Third, so let me complete. So third one is partially for official use and partially for personal use. In a judgment on LIC Officers Association judgment, they have said that commute from home to office and back is not for the official duty, is what they have said. So they have categorized these 3 things separately. So in the first one, where it is commute from office to work and back, if we are saying that the employer is incurring expenditure towards that, you are absolutely right, 17.2 applies. If it is the other 2 cases, then it has to go under this.
but 17.2 has to be computed keeping in mind with the perquisite rule.
No, absolutely, I agree with you on that. So I am not even disagreeing with you. I completely agree with you on that. For the first case, 17.2 applies. For the second and third, which is partially usage, 17.2 does not apply, then perquisite value has to be directly done. Where 17.2 applies, there also perquisite value has to be considered. I am with you on that. Thank you, sir.
The previous,
Yes, sir.
so the first and second one is perquisite amount and the third is the exempt.
Exactly. So that's the key thing. First and second is the perquisite amount, where the vehicle is,
Taxable.
which is taxable. In the third case, where the vehicle is owned by the employee, the balance is taxable.
And for example, in the first case, if the employer incurs 10,000 rupees, so 5,000 is perquisite. So, but he will still account the 10,000 rupees
That
as
is
a
a cost,
business
that's a
expenditure.
business expenditure, repairs, maintenance, conveyance, petrol charge, whatever, they will
The
account.
entire 10,000 is allowed.
Absolutely. Absolutely. There was no specific provision for electric vehicles. So under the old law, now under the new rules, the electric vehicles are also added into this entire perquisite value. on the on that side I have given a evolution how it happened. Rule 3 did not have it separately under the old law. Apply because electric vehicles does not have one cc's, right? So it is not measured by way of a few liters cc. So that is not how electric vehicles are measured. So basically the rules never applied for it. So therefore there was request made, stakeholders did make representations, and even the draft rules, 7th February it was not there, but suddenly when the rules got notified on 31st March, if I recollect correctly, they had bought in. What did they do? They said that electric vehicles should be considered on par with less than 1.6 liter cubic capacity. This is what, like a small car, let's call it a small car, big car. Irrespective of the size of the electric vehicle, they said that all the valuation what applied here for a small car will apply in the case of electric vehicles also. That is what they have done. Looks like it is a nudge for people to move towards electric vehicles. So this is the other thing that I was trying to talk about. So I just have a couple of slides I finished, then we can discuss on the questions. So other perquisite valuation, rule 15. So some thresholds have increased. Concessional education facility, if there was being given by the employer, exempt up to 1,000 rupees has gone up to 3,000 rupees. Interest free or concessional loan, the interest imputation into the perquisite value was not required up to loan of 20,000 rupees. Now it has been increased to 2 lakh rupees. If an employer grants a concessional interest loan or an interest free loan up to rupees 2 lakh rupees, now there is no imputation of perquisite value that needs to be done. If it has to be done, the rules are the same, SBI, PLR rates and all of that. So those continue to be the same. Third one is free food or non-alcoholic beverage and meal vouchers. What used to be earlier food coupons in the form of Sodexos, etc. being given, this used to be exempt up to 50 rupees per meal. Now the exemption has increased to 200 rupees per meal. Gift vouchers and tokens used to be exempt up to 5,000 rupees per annum. Now the value has increased to 15,000. All of these perquisite valuations and exemptions can be considered even under the new regime. That is an important takeaway, at least as of now. The law as it stands now, all these can be considered even in the case of new regime. If the salary component has, let's say, a Sodexo coupon, up to 200 rupees per meal per working day, some take an interpretation, it can be 2 meals also. There was one old FAQ which had said that it can be up to 2 meals. That continues, there is no law to that extent, there is nothing in the rules which says how many meals. It says meal during working hours is what it says. So there is an interpretation to say it can be 2 meals also. Now, let's not go into the aggressive interpretation. So going by the conservative interpretation, 200 rupee vouchers can be given under the new regime if it's part of the CPC. To that extent, there is an exemption as well. So that is the important thing. Now, this is one anomaly that I saw. So,
sir, the previous time, when we talk about the interest-free loan up to 2 lakhs, if it is about 2 lakhs at what rate it's...
So the SBI PLR rates, prime lending rate of State Bank of India is the rate at which it has to be considered.
As per.
As a proposal. If it is interest-free, entire value. If it is concessional interest, the difference between them. This anomaly is okay. So the background to this is, initially, new regime used to be an opt-in regime. Right? So old regime was by default, new regime was an opt-in, you had to opt in to it. Later on, from financial year 23-24, new regime became the default regime. There is no opt-out. Right? So you have to opt out into the old regime. Now what has happened? In Rule 280, it says that there are certain allowances. 280 gives you the exempt value of the allowances which are exempted. In that, they want to restrict the exemption to somebody who has exercised an option under 2024 is what they say. Now, under the new law, the 2024 is an opt-out. Now, theoretically speaking, what is happening is they are trying to say that I want to restrict the allowances under the, the intention seems to be to restrict it under the old regime and give it under the new regime. But because of this change, it has become reversed now. This, according to me, looks like a drafting error. But that is the reality. Till the amendment is done, that is the reality. Now, therefore, what has happened, if somebody is in the default regime, the number of exemptions that they get are more than if they opt out to the old regime where the number of exemptions go down. This goes against the government's intent of introducing the new regime. Where they said that we wanted to do a regime where there are lesser exemptions and deductions, this goes against it. But if it is consciously done that way, it helps a lot of people. So that is what it is. So last slide on my presentation is on the new labour code. So how the new labour code has been drafted, in very simple terms, there were n number of acts. They are now made into 4 codes. One of them is Code of Wages 2019. Code of Wages 2019 gives you the definition of the word wage. Now that definition is now consistently followed for Code of Social Security Benefits and all the other codes as well. Now there are 4 layers to it. This is the anatomy of how the wage definition is there. The first layer is an inclusion layer. Let's call it an inclusion layer, where basic pay, dearness allowance and retaining allowances, they call it. Now, what is retaining allowances? There are multiple FAQs that the government has released and all of that, etc. If there is no other meaning, name given to it, then such allowances are called retaining allowances. There is a practice to include special allowance, right? As a balancing figure, if you see in a lot of salary structures, you have a special allowance. Now that becomes part of your layer 1. So what are these layers? How does it impact? I will come to it in the end. Layer 2 are exclusions. So there are quite a few. HRA, house accommodation, that is rent-free accommodation, PF, conveyance allowance and travel concession, overtime allowance, commission, bonus, variable pay which are linked to performance, etc. They are all in the second layer. Third layer is gratuity, retrenchment compensation, retirement benefits and ex gratia. This is the third layer. Why am I layerizing it? I will tell you again. Fourth layer is remuneration in kind. It could be the Sodexo coupons, it could be gift vouchers, it could be any remuneration in kind. What has now happened is that when you compute the overall wage for your denominator, all the 4 layers you have to add. Your layer number 2 cannot be more than 50%. This is what the new labour code has said. So there is a misconception to think that if my basic pay is already 50%, I am compliant with the wage definition under new labour code is incorrect. Because there could be certain things like gratuity, you are not making it as a part of your, you are not computing gratuity and not making it as a part of your total wage. Now under the new labour code, you will have to add that also into the denominator while computing the 50%. And your layer 2, which are all the exceptions, cannot be more than 50%. If it is more, that more is added into layer 1, and layer 1 is the layer on which you compute gratuity, you compute provident fund, you compute leave encashment if at all you are supposed to give leave encashment, and it is also used to compute bonus if statutory bonus has to be given. So therefore it becomes important to understand that componentizing the salary, keeping both new labour code in perspective and the new income tax rules have become a necessity suddenly. Otherwise, in one of the companies we estimated the gratuity liability, if they had not recomputed it or restructured it, was going up by about 22 to 25% on an average. The gratuity cost was going up, and that was a 500 plus people company. So imagine the number of exits in the gratuity payouts. And there was a, you might have also seen Institute came out with a guidance note in December, if I recollect. They said that because the new labour code became a law from 21st of November 2025, they said that for the quarterly results that the listed companies declare for the Q3 of financial year 25-26, they said that you have to consider the new wage and recompute the gratuity and make a provision even for the quarterly reporting is what the institute came out with. Therefore, in your year-end audits now, you will have to consider the new definition of wage. In our conversation with actually also they are also taking the same position that they are computing the wage as per the new labor code. Because for 25-26 you can't make any change. If at all you can restructure your salary, you can do it now, right? So what has happened has happened. Therefore the gratuity computation has to be done on the definition which is there under the new labor code. So this is what I wanted to leave you all with. This is the planned content that I had to talk to you. We slightly ahead of, we exceeded the time. Maybe one or two questions I can take. And then
I refer to section 17 clause H saying that employee contribution to each plan up to 7,50,000 is taken from market. Now, you also look at the matching contribution to be made by the employer of the contribution made by the employee. Employee contribution, matching contribution to be made by the thing. Now, over and above the matching contribution the employer contributes, is it not exempt?
it is not exempt.
Why is it not exempt? There is no such a condition under 17H.
Now 17H says that up to the contribution limit that have been given.
No, 17H only says ceiling up to 7,50,000. Whether there is or not, that is an independent issue. See, there is some other. This is where you need. Aggregate amount of any contribution in excess of rupees 17,50,000 is included. It means contribution up to 7,50,000 is exempt.
Correct. Contribution up to 7,50,000 is exempt.
Assuming that my contribution is 10,000, employee contribution 10,000, 1,20,000 rupees. Okay, employee contribution is 10,000 into 1,20,000. Over and above my contribution, if the employer contributes 750 minus 120 is 6,70,000. If you contribute to that. PF, product of amount. That is over and above my contribution. Is it not exempt?
It is.
It is exempt.
That's what. It is exempt. It is exempt. I agree with you, sir. The threshold of 7,50,000 is correct.
Therefore, but is there any taxation of excess contribution made with employee, over the employee contribution is also taxable?
No.
And there is also interest on that amount of PF contribution.
All those the base limit is 7,50,000. Anything above that is only what is to be considered.
Over and above the principal contribution, interest and that amount is also taxable.
That's correct, sir.
Okay. Now, is there any, which is the exemptions, which is the chargeability section, which says that any contribution over and above the employee contribution is taxed?
So, in the definition of income, they have added it, sir. In 2-49, in the definition of income, they have added it. That is why it becomes part of the income, and exemption has been given to a certain limit. Beyond that is taxable. That is the way to interpret it, sir. And salaries is an inclusive definition, so it includes all of this.
Sir, one question.
Yes.
I remember you have been telling that exemptions have been now treated to be an income until deduction has been
Right.
reached.
Correct.
So some of the Rule 3 exemptions from the purposes
Correct.
have been now available in the new regime also is what
Correct.
you have mentioned, because directors specifically removed that for example.
Correct.
Whether these exemptions also could be interpreted and then said that it's a deduction, therefore section 220 of the 115 BAC would not allow any deductions.
No, that can't be said. The reason for that is, if you look at the definition of salary under section 17, it says that perquisite is one of the salary. How to compute perquisite is completely given in the rules. So only after you apply the rules fully and compute it according to those rules, you come back and comply with the value of the perquisite. So therefore you can't say that.
So that doesn't become a deduction from the
It doesn't become a deduction.
Sir, I think this question will be useful for all of us.
Yes, sir.
Sir, our employee CTC is 30 lakhs per annum. Monthly gross is 2 lakhs. 2 lakhs is the total 24 lakhs. Balance 6 lakhs is employer contribution, gratuity and all these things. Now we have made it as a monthly gross. Basic salary is 1 lakh. There is 2 lakhs divided by 2 is 50% of basic. 50% of the gross is basic. Now you are told that this is not right because
When you say it is not right, I said that it is not enough.
Yeah, it is not enough. Then I need to increase the basic or decrease the basic.
So what you have to do, you may have to restructure within the 30 lakh what you are giving. For example, let's assume, sir, in the gratuity value was not considered.
Yeah.
In your example, is it considered? Not considered.
It is considered.
So in the 30 lakh, in that 6 lakh, what you said, delta
Yeah, in that
gratuity
it
is
is
also
considered.
included.
Yes, yes.
Now what has to happen is that if on the 30 lakh, 50% is 15 lakh. So 1.25 lakh rupee per month becomes your base. So you have fixed 1 lakh as basic.
Yeah.
For your denominator, you have to consider all the 4 layers.
All the 4 layers.
That is the important change that has happened, sir. But merely by fixing 1 lakh as basic, which is let's say 50% of the 24 lakh, is not enough.
It is not enough.
Yeah. That's the change that has
Companies are doing like this only.
This is a very important thing. That is why I thought, though I am sketching beyond the income tax law, I thought I should mention because this thing, the attention on this has not gone.
Thank you, sir. Thank you very much.
Salary income includes contributions L17. It means
We will take this offline, sir. We will discuss this. Thank you so much.
Can I request all of us to stay back till we finish, at least handing over the momentum. Speaker has been there and he spends his time. When
Thank you.
everybody walks up and there is nobody in the hall, it is not looking good. So please stay back. We will finish it immediately.
Thank you very much, Krishna sir, for such a wonderful session on salaries. Very interesting topic.